Ohio's First Appellate District of Ohio, with the Honorable Judge Marilyn Zayas presiding, is now in session. Please be seated.
Good morning. Good morning. Welcome to the First District Court of Appeals. It's Tuesday, March 29th. We have a fairly full docket. We have 4 cases that are scheduled for argument this morning. We have 5 cases on the docket this morning. And I'm going to review them in the order that we will be hearing them this morning. So the first case that we will be hearing is State of Ohio versus Angelo Howard. Parties, if you could, yes, thank you. Identify yourselves and your readiness to proceed.
Good morning, Your Honor. Donald Castor on behalf of Angelo Howard. We are ready to proceed this morning, Judge.
Okay, thank you.
Sean Donovan on behalf of the state, ready to proceed.
Thank you. Then we have Staley v. Phillips.
Richard File on behalf of Ms. Staley.
Good morning.
And Your Honor, Paul Croushore on behalf of Ms. Bryce Phillips.
Thank you. We have Dennis v. Dennis.
On behalf of the appellant, Your Honor, Robert Kelly.
Good morning.
William Laws on behalf of defendant appellee Nicole Dennis.
Thank you. We have State of Ohio versus Evanson, which has submitted on its briefs. And the last case we have is State of Ohio versus Ricky Brown.
Mike Trapp, for appellate, ready.
Good morning.
Paula Adams on behalf of the state of Ohio, ready to proceed.
All right. So we'll begin with case number C210285, State of Ohio versus Angelo Howard. Good morning again.
Good morning, Your Honors.
Good morning, counsel. Would you like to reserve time?
Yes, Your Honor. Respectfully, we'd request 3 minutes for rebuttal, please, Your Honor.
All right. You can start whenever you're ready.
Good morning, Your Honors, and may it please the court. Appellant Angelo Howard had been incarcerated for over a decade for crimes that he did not commit. Since the time of his trial, 2 things have come to light. First of all, following the trial, the state of Ohio destroyed biological evidence that it had a statutory duty to preserve. And secondly, Your Honor, prior to trial, the state of Ohio suppressed exculpatory evidence that undermines the confidence of the verdict in this case. Either or both of these were sufficient grounds to grant leave to file a new trial motion. The court below erred in concluding otherwise. First of all, Your Honors, with regards to the issue of post-conviction destruction of evidence. In this case, as was his statutory right, Mr. Howard, through counsel, filed an application for post-conviction DNA testing. There were several pieces of evidence that were recovered by the police that would have been outcome determinative, that would have been dispositive, had they been tested for the presence of DNA. Those items included bindings used to bind the hands of a victim in the cases. They included shell casings from a gun fired, and they included, in fact, the murder weapon.
And how are you saying that this would have been dispositive? Do we know for sure that there was biological evidence on these items?
Well, 2 things, Your Honor. Of course, we never know for sure that there was biological evidence. And in fact, the statute doesn't say that evidence has to be preserved only if we're sure that there's biological evidence. Instead, the statute at 293382B2 says that it applies to all evidence likely to have biological material on it.
This is any item that contains, right?
Pardon?
Any item that contains blood, semen, hair, saliva. Right.
That's correct. That's how biological evidence is defined, Your Honor. And biological material is defined perhaps even more broadly as any product of a human containing DNA. And the statute specifically says at B2 that it applies to any piece of evidence likely to have biological material.
Wouldn't that be any piece of evidence that is at a crime scene?
At this point, Your Honor, it may very well be. It would likely be lots of pieces of evidence. But also, I'd urge the court to remember that the statute itself has a limit to it, right? The statute only applies on its face to those cases that are murder or rapes. Most crimes are not included in the evidence preservation statute that the General Assembly passed, and that's because the General Assembly presumably wanted to save for the most serious offenses and the longest terms of incarceration the opportunity for individuals to seek post-conviction DNA testing. So it's not every case and every piece of evidence that would have to be saved.
It would be every piece of evidence in those particular cases, though, right?
In those particular cases, and again, there would need to be a case-by-case determination. But in this case, at least, because there was no evidence that the offender used gloves when handling the gun or the shell casings or the handcuffs used to bind a victim, there was likely to be biological material on the evidence. And for what it's worth, the General Assembly...
Let me ask you a question.
Yes, Your Honor.
All those items were available prior to the trial, and I know that the defense counsel did request DNA testing on those items. Could that have been a trial strategy? Because sometimes you want to be careful what you ask for.
Well, the record doesn't contain any evidence that that was trial strategy. And quite frankly, Your Honor, in 2010, no. By 2013, when the evidence is destroyed, we're looking at a slightly different picture. But in 2010, certainly there was no capacity to test shell casings at that time for DNA evidence. As to the other items, again, we're looking back in time some 12 years to DNA technology being not quite as good. And it's not clear at all that touch DNA would have been readily available in 2010. But I'd also urge the court to remember that we're simply at the motion for leave stage here, not the motion for new trial. That might well be a defense for the state on a motion for new trial, but we're at the leave stage.
The judge didn't even examine the unavoidable prevention piece of this, right?
The Judge Gehring did not. The state's primary argument in this case was based on reasonable diligence, that it wasn't even the 120 days issue. It was, the evidence was, at least what the state seemed to argue both below and in the briefs to this court. Well, if the evidence, according to the state, was destroyed back in 2013, then at some point before the motion for leave to file, certainly Mr. Howard could have found that out. Unfortunately for the state, the reasonable diligence argument is now squarely foreclosed by last week's Ohio Supreme Court decision in State versus Bethel. In State versus Bethel, issued just 1 week ago today, the Ohio Supreme Court said that trial courts do not have the discretion to add on to Rule 33 a reasonable diligence requirement. That was a 7-0 holding of the Ohio Supreme Court.
Was that just with regard to Brady?
No, that was with regard to everything, Your Honor.
Okay.
What the court said, and it was written by Justice Fisher. Justice Fisher took a very textualist approach to Criminal Rule 33, and Justice Fisher said, look, the rule said either it's discoverable within 120 days or it's not. And in this case, or in the case that was looking at in Bethel, it said, look, the court below, which was Franklin County, the Franklin County Court applied a reasonable diligence standard. It agreed that the evidence couldn't have been found within 120 days, but that nonetheless the defendant should have brought the motion in that case prior to when the defendant did. And the Ohio Supreme Court said that's beyond a trial court's discretion. And that's what happened as well in this case, Your Honor. Mr. Howard could not have known in 2010 that the state of Ohio would destroy evidence in 2013. That's not what's here. Whether or not the evidence would have been outcome determined, and I'm prepared to argue today that it was, again, could be an issue adjudicated at the motion for new trial stage. Again, we're at the motion for leave. And on leave, the trial court erred. The trial court should have granted leave in this case and advanced forward to a motion for new trial. Moreover, with regard to the right at stake, I want to make sure that my argument with respect to the right at issue is clear. We recognize, of course, that there is no constitutional right to post-conviction DNA testing. But as we point out in the briefs, what's happened in Ohio is that Ohio has created a statutory interest in post-conviction DNA testing through its statutes, through the combination of both the opportunity to seek testing and the statutory duty on behalf of police departments and prosecutors to preserve DNA evidence. In destroying the evidence, the state of Ohio deprived Mr. Howard of his right to procedural due process, which is a core constitutional right going back to the 1970s in the Goldberg versus Kelly
But
case.
is that before us if we're ultimately to decide the issue on leave?
That's unclear, Your Honor. In case the court thinks that it's before it, I wanted to make it clear that there is a constitutional right at issue. With respect to the issue for leave, though, the question is, could Mr. Howard have discovered the post-conviction destruction of evidence that wouldn't occur for another 3 or 4 years? No, of course he couldn't have. And in fact, even at the destruction stage in 2013, the record makes it look like the state of Ohio took some pains to make sure that Mr. Howard couldn't find out that it happened. As we walk the court through in the brief, and as was shown in the hearing before the trial court, which was on the underlying application for post-conviction DNA testing, not on the motion for leave. There was no hearing conducted on the motion for leave. With respect to the evidence in this case, the state of Ohio filed a motion to transfer the evidence from the custody of the court under a caption of one of the co-defendants, not who had pled guilty, who wouldn't even have a right to seek post-conviction DNA testing in his own case, rather than seeking the transfer of the evidence in Mr. Howard's case. And when the city of Cincinnati asked for permission to destroy the evidence ultimately, it did so under what the clerk of courts for the Common Pleas Court calls a miscellaneous case number. It didn't even appear under the B number.
So ultimately, you're asking us to determine that there was bad faith, and that's the crust of the due process violation, if we were to go there.
Well, Your Honor, we don't believe that if the court likens this to a post-conviction Youngblood case, then the issue would be bad faith if we look back to through the Youngblood line of cases. But for a procedural due process claim, there doesn't have to be bad faith, Your Honor. With respect to procedural due process, the Sixth Circuit's decision in the Brotherton case, which is cited in the brief, is particularly on point in this case. That case involved the destruction of corneas of deceased individuals. The Sixth Circuit found that in destroying corneas, contrary to Ohio statutory law, the coroner's office had deprived the family members of deceased people of a procedural due process right to direct disposal of those corneas. And there wasn't a bad faith finding in that case, and that didn't have to be. And in fact, what the court said in that case was that the coroner's office was proceeding according to its policies and practices. And it's clear in the record in this case that that's what the Cincinnati Police Department was doing. It never changed its policies from 2009 to 2010 when the evidence preservation statute went into effect. Instead, what happened is the city would simply destroy evidence anytime it needed more space in the property room. And to decide whether it was okay to do it, it would simply ask the lead detective on the case whether he or she had any more use for the evidence. That's clearly not what the statute requires, and that results in a deprivation of Mr. Howard's procedural due process rights. The state of Ohio fell down on this case. The only remedy for Mr. Howard is a new trial at which the spoliation of evidence is given in an instruction to the jury. With respect to the other grounds for motion for leave, Your Honors, the pretrial.
You have a minute left.
I'm sorry?
You have 1 minute left.
Okay, I'll be brief, Your Honor. I apologize. With respect to the pretrial suppression of evidence in this case, the court below clearly erred under this court's decision in State versus Carasone in denying leave without a hearing. The trial court held no hearing on the motion for leave in this case. The trial court simply reached the decision it did with respect to the Brady material. This was a case that rested on very thin evidence, Your Honors. So it doesn't take a whole lot of Brady evidence to undermine confidence in the ultimate outcome of this case. And here we know now, a witness who looked at a lineup that had Mr. Howard in it and chose someone else anyhow. And we didn't know that Mr. Howard was in that lineup. We also know that there were fingerprints of value and testimony directly to the contrary was given to the jury with respect to the presence of fingerprint evidence. The jury didn't know that. The jury should have known that. But more so, the trial court in this case should have conducted a hearing on the motion for leave. Your Honors, with respect to the post-trial conviction of evidence, we'd ask that this case be remanded with instructions to grant Mr. Howard leave to file a new trial, or with instructions to grant Mr. Howard leave to file a new trial motion. With respect to the second claim on Brady, we ask that the trial court reverse and remand with instructions to hold a hearing as is required by this court's precedent in State versus Carasone. Thank you, Your Honor.
Thank you.
Good morning, Your Honors.
Good morning.
Well, the bulk of the argument and the discussion was about the DNA evidence and the court's ruling on that, so I guess I'll begin there. The court ruled that there was absolutely no argument made as to why the handcuffs, the firearms, the shell casings constituted DNA evidence, biological evidence that was required to be maintained under the statute. And as Judge Krause was talking about, there's merely speculation that maybe touch DNA might exist, and touch DNA might exist on anything. And I think it's significant to remember when we're looking at this and when we're talking about this, that the murders occurred in 2002. That predated the collection of touch DNA evidence. There was none collected. There is absolutely no argument that touch DNA, any samples were collected. Had those samples been collected, we would be in agreement with Mr. Castor that those samples would exist. What we have here is speculation that maybe it existed.
How do you interpret the statute, the definition of biological evidence, which not only includes samples that are taken, but it looks to clothing and bedding and drinking cups, containers, cigarettes, and I mean, I assume that would be items that may possibly contain.
Right, and there
right?
are, the statute does say that biological material incorporates items that are likely to contain. So like a blood-soaked shirt, or, to use an impeachment reference, semen on a dress. A DNA, a rape kit. Those are the kind of things, the rape kit where there's an actual sample.
What about cigarettes, though? It's specifically cigarettes, and we have cigarettes in this case that were destroyed.
I don't know that, the cigarettes weren't the focus in there, and there wasn't a ruling on that in terms of the cigarettes. I would have to look at that.
What are the zip ties? And we know
the zip
that
ties and the cords and everything like that. We're still, once again, we're speculating as the possibility of touch DNA. There's been no evidence. There's been no testimony that evidence was likely to be contained. That was likely.
So that's the only way the state is required to preserve these items, is if there's some sort of indication that DNA evidence likely is on them.
Yes, ma'am. In terms of the statute, it says biological material includes things that are likely to contain. So in a cigarette, you have saliva. It is something that has been in the person's mouth. In the case of a teacup or a coffee cup or something like that, once again, you would have backwash. You would have contact with the saliva, with the mouth, in those sort of instances. In this instance, we're talking about the speculation that touch DNA might exist. There's absolutely no indication that it did exist. Beyond that, touch DNA was readily available in 2010. Contrary to what counsel was just saying, there's testimony from the officer that it is now. At the time of the trial, he said that in 2002, we weren't swabbing for touch DNA. Now that's standard procedure.
So the argument is that Mr. Howard, at the time of the trial or getting ready for trial, should have asked the court to give him money for an expert to do DNA testing on all this stuff?
Yes, Your Honor. I believe that he's on notice at that point. So we're not waiting until 2013 for it. 5 years after he's indicted, now we wait 5 years, or even a year and a half after the court, the Supreme Court declined jurisdiction on his direct appeal. That's when finally the evidence was disposed of. None of these arguments were raised until years and years later. The 120 days doesn't start, when they finally get around to asking for it. It was a simple matter that could have been, they were on notice at the trial that touch DNA existed. If they wanted to pursue that, as Judge Winkler, as you were saying, perhaps it's trial strategy. They didn't want to know the answer to that. I don't know the answer to that. What I do know is that they were on notice. It's in the record that it was readily available. In fact, one of the cases that they cite, I believe it's a Phillips case, talks about the advances in touch DNA, and that case predated the trial by, I believe, 5 or 6 months. So touch DNA was readily available in 2010 when the trial was going on, and yet waited 8 years before bringing up the issue. So we don't get to retroactively go back, and now there's bad faith. Their time for filing a motion had expired years prior to the DNA or the evidence being disposed of pursuant to the court order. Additionally, everything that they're talking about, all of the evidence that wants to be tested now, was submitted as evidence at the trial. I mean, it's sent back with the jury. It's on display on the prosecutor's table. There's absolutely no evidence. There's nothing in the record to even remotely indicate that it would be in a forensically sound manner, that it had been maintained in that
So
manner.
you're saying all of that evidence was taken out of any kind of packaging and handled by multiple people?
I'm saying that, yes, Your Honor, there's certainly indication on a great many of the items, the firearm, the shell casings, and the handcuffs. There's testimony in the record as to those being removed from their envelopes during the trial. Then that evidence is then sent back with the jury for the jury to examine and to have at their disposal as they're making their decision on this. So it's strange, you know, if touch DNA is likely to occur, then the DNA that's going to be on there is Rick Gibson, the trial prosecutor, defense counsel.
We would be assuming that as well, though. I mean,
but it's also a frangible item. It is something that isn't permanent. It can get wiped away. It can get, now we're going to get into secondhand, transference, and all these other issues.
But isn't there also a concern of evidence that was not disclosed, the photo array?
That's getting, yes, ma'am, and we'll get to, I can move on to the Brady claim, which was the final portion. In terms of the photo array, Brittany Kelly, who was the witness in there, was cross-examined on her misidentification.
Yes, my question with regard to that is, when is it that defense came to know about the issues with regard to the photo array?
And I'm not conceding the issues, but their claimed issues arose out of their, I believe it was 2018, when they filed a public records request for this evidence, 8 years after.
Couldn't it be said that that then is then intertwined with the issue of the DNA? In other words, once the defense is alerted that there is an issue of identity, and that then causes then defense to say, oh, well then let's pursue DNA because that can support that my client is not the perpetrator.
I could get, certainly the statute for the testing of biological evidence, there are 6 requirements in there. And in order for biological evidence to be appropriate, identity must have been one of the questions that was raised at trial. The identity of the perpetrator had to have been an issue at trial. It was an issue at trial. Whether or not he was the perpetrator was at issue. So identity was clearly already known at that time.
Right, because he was saying I'm innocent. So, but that's different than having actual evidence of an issue with the photo array.
But, Your Honor, Ms. Kelly was cross-examined on her misidentification, her identification of this individual known as Jabber. And if you look through the transcript as to what she testified to, she said she never actually saw the shooter's face. She didn't get a good look at the shooter. That based on the silhouette and reputation, she thought it was this guy, Jabber.
but defense counsel wasn't given the information that she was actually shown a photo array that included Mr. Howard in it and did not pick him.
I don't know whether that That's certainly their.
That's what they say.
That is their allegation. Yes, ma'am.
And there was apparently a sticky note on that when they got the public records request that said, don't turn this over or something like that.
Now, in terms of the sticky note, it doesn't say don't turn it over. I believe it says do not release, just file in terms, and that wasn't, I don't believe that was on the photo array. I believe that was on the fingerprint worksheet for Michael, I believe it's Johnson, whose fingerprints were discovered on a sandwich box that was at the scene. And in terms of that, we have no idea when that note was put on there, who put it on there, any information as to that. So I would...
So you're saying it should be ignored?
I'm not saying that it should be ignored, but I'm saying that it should be granted minimal weight in terms of that if we're going to speculate as to bad faith and bad acting on the part of the state. The fingerprints and everything that were in question in the worksheet was done in 2002, 5 years before Angelo Howard was even developed as a suspect in there. So there's absolutely no reason to suppress or to hide anything at that time. They're trying to develop witnesses. There's a discussion about a value quality fingerprint being found on the magazine. The report does not say fingerprint. The report says print. And it is quite possible that it's a palm print. And there wasn't a palm print database at that time, which explained why it wasn't, when they're trying to, in 2002, they're trying to develop whoever they can, that if that print could have been submitted. And there's no allegation and there's no evidence that that print was submitted, that a result came back and that was suppressed, although that has to be the implication that is being brought here. In 2002, they wanted to know who it was. Carlos and Eugene Jackson, the co-defendants who testified against Mr. Howard, had not come forward at that point to implicate him. And so we have to remember the timing on when all of this happened. The fingerprint and the analysis of that happened, or the palm print, or the print on the magazine, or any of the prints, were taken years and years prior to that. And by waiting until 2018, well, now the analyst who took the fingerprint and the criminalist who took it, one isn't on the force, two, one of them is no longer with us. We have no way of cross-examining. We have no way of talking to them. That's why it's significant that the time limits and the unavoidable prevention. And I want to bring back, in terms of discussion about Bethel and everything like that, there's no supplementing of the record. I don't have an opportunity to respond to that argument, which is being raised for the first time here in oral argument. Yes, I understand that it's an Ohio Supreme Court case, but that it was going to be applied to here.
Did you read the case when it came out?
I have not, Your Honor.
Okay.
So
it is on point.
I can't disagree with that. However, raising it for the first time and it having come out, there could easily have been, clearly counsel was aware of it. I had other duties that I was working on, and that's my
We have to consider that case.
I understand, Your Honor. I'm just saying that, raising it for the first time in some of the arguments in some of the other cases, I believe the Cornea case that's being discussed, is stuff that's being thrown out for the first time at oral argument, and that's not appropriate. But in terms of that, and in terms of the 120 days, as I understand the argument that's being raised, the 120 days in terms of the DNA evidence and everything like that, you were on notice back then. 120 days had run. It was discoverable back then. All it took was a request for it, as was evidenced by 8 years later, 8 years post-conviction, a simple request got all of this information and started this ball rolling. That could have happened in 2010, it could have happened in 2011, it could have happened in 2012. So the 128 days is kind of the 120 days is kind of a red herring in this case. I don't believe that it's appropriate in this because it's not something that wasn't discoverable at that time. And so that would be my argument as to that. is if there are, in terms of unavoidable prevention, which is kind of how, Judge Krause, how you had started out here, there's absolutely no indication and no argument as to any diligence or any reasonable efforts that were taken for 8 years after trial before this happened. At some point, the statute has to come into play. And I realize that the trial court did not rule specifically on it. It ruled on the merits, and it said that there was no argument that touch DNA existed in this, so we're not applying the touch DNA statute, and it said that there weren't the Brady violations, and therefore that wasn't private. But the unavoidable prevention is still relevant, and on this record, it is still clear and plain that nothing was done for 8 years, and that has to be too long in this matter. If there are no further questions, I'm assuming I've run out of time a long time ago.
You're right on the money.
Good morning, Your Honors. I'd like to make 2 points as quickly as I can, Your Honors. First of all, with regards to the post-conviction destruction of evidence, the version of the statute that the state offers before this court today is consistent neither with its text nor with its history. Remember, Your Honor, Senate Bill 77 was adopted in 2010. This wasn't a concern anymore about catching rape kits from the 80s and 90s. And in fact, as one of the judges on this bench pointed out, the statute is broadly written, both with respect to the types of evidence that it covers and the types of biological evidence that it covers. It's not just about rape kits and swabs anymore, and it wasn't in 2010. It's about evidence. It's about if the state of Ohio could simply say, well, it's not biological evidence because we didn't swab it, and therefore there's no sample, it could defeat the intent of the General Assembly every time. And that's not what the statute says. The statute said that the items of evidence that are likely to have biological material, and biological evidence isn't just semen and it isn't just blood, it's also saliva and skin, so touch DNA is specifically accounted for. Moreover, in 2010 or 2012, no one was testing shell casings for the presence of DNA. We gave some history of that in the briefing to this court as well as in the underlying application for post-conviction DNA testing. That wasn't available to the court. Also, there's always speculation as to whether or not the evidence is contaminated or not. There were multiple viable alternate suspects in this case, some of whom are no doubt in the CODIS database because at least one of those suspects is already in prison on death row serving time for 2 unrelated murders of his own. Your Honors, had CODIS been used, had all of the evidence been tested using an anchoring effect where we make sure that the same profile is on multiple pieces of evidence, testing would have been outcome determinative, but the state's violation of Ohio law in this case deprived Mr. Howard of that opportunity. And finally, with respect to the Brady evidence in this case, the state makes much of, 8 years or 10 years or however many years passed before Mr. Howard filed a request for public records. But the law is clear. That's not how a post-conviction Brady claim works. There's multiple cases in which this court and the Ohio Supreme Court has said the state doesn't get to hide exculpatory evidence and then turn around to the defendant and say, you didn't find what we hid in time. That's not the law. The state was required to disclose the presence of these prints after its own expert took the stand and said that there were no prints. The state was required to disclose to the defense that not only was Brittany Kelly pointing to a person who couldn't have committed the crime, but that she looked at a picture of Mr. Howard and affirmatively said it was someone else. Mr. Donovan says, it doesn't matter. That wasn't his call. That wasn't Mr. Gibson's call. That was the jury's call. The jury should have had that evidence in front of it. And again, Your Honor, with respect to both claims, I'd urge the court to remember where we are procedurally. We're at the leave stage. With respect to the post-conviction destruction of evidence, the case should be remanded and the trial court should be instructed to grant leave because there is a hearing on the underlying DNA application that sets forth the state of Ohio's and the city of Cincinnati's systematic destruction of evidence. With regards to the latter issue, the Brady claim, Carazone clearly says you cannot deny a claim like this without a hearing. This case should be remanded with instructions to conduct just such a hearing. The things that the state says we don't have, like an expert testifying about whether or not testing would be successful, first of all, the statute leaves that to the testing authority, not to the trial court. And secondly, the reason we don't have a record is because these motions were denied without hearings. That was error. This court should reverse and remand. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a great afternoon. We're going to take a brief pause. Staley v. Phillips.
Morning, Your Honors.
Good morning.
Richard File on behalf of Ms. Staley.
Would you like to reserve time?
I don't think so. I'm going to be fairly brief, Your Honor.
Okay.
When I can begin whenever the court is prepared.
Whenever you're ready.
Judge, I think that this issue is very narrowly tailored. This is an abandonment case. Question is, did the trial court miss it or did the trial court get it right? If the trial court got it right, then we can't do anything further. If the trial court got it wrong, then we have to make a determination as to what's step two. Step two would be looking at damages. At this point, we conclude and assert that the court missed the mark in defining what actually factually happened pertaining to abandonment. And quite succinctly, abandonment has been defined in the Hamilton v. Harwell case. The trial court addressed that issue. The trial court also addressed the issue of Markovich v. Hunt. Abandonment is essentially an unequivocal relinquishment of property rights. In looking further to the Markovich v. Hunt case, which is in the brief, you have 6 essential elements that the court pointed out, the Markovich court pointed out. It says no rent was paid by the tenant, no effort by the tenant to get the property, the tenant admitted to moving, the tenant turned off the electric, the tenant left the door unlocked, and the tenant's items were left next to bags of garbage. Those are different situations that we're dealing with what happened to Ms. Staley. Ms. Staley was on an ongoing dispute.
Well, in that case, the tenant had terminated the tenancy, right?
In Markovich? Mm-hmm. I think that the facts indicate that that's clear, yes.
Okay. So wouldn't there need to be a termination of tenancy in order for there to be an abandonment of property within?
Well, I think abandonment is factually determined as to what the tenant does. And I think clearly the easiest example of an abandonment of property is when you turn in your keys. You're saying, I don't have an interest in this property anymore.
So that goes back to what I'm saying. Wouldn't there have to be an ending of the tenancy?
Yes.
Before we even get to the issue of abandonment? Whether it's by surrender, whether it's by agreement of termination, whether it's by a communication of termination.
I think that that's probably a fair assessment of what you're actually looking for. But I think under the circumstances here, we had all kinds of disputes going on. Textually, face-to-face disputes. There were issues as to Ms. Phillips indicated, well, you removed some property, but there was property in there. It was classified as trash. There are certain cases cited
So
throughout.
what I'm getting to is, did she ever terminate her tenancy?
Ms. Staley did not, and I think that the testimony was clear. I'm not leaving. Sue me. Take me to court. That came out at the trial. And even though that a 30-day notice may have been issued, maybe a 3-day notice was issued, there's some dispute as to whether or not that was actually done. It doesn't matter. What matters is that no forcible interim detainer action was obtained in the court system and no writ of restitution was obtained. So the position that Ms. Staley has is that Ms. Phillips entered the apartment without a court order. It doesn't matter. You can be 15 months behind on rent, and if you don't have a court order and somebody still says that I have a tenancy to this, you have a possessory and a property right to that unit, and you got to have a court order to throw them out.
Now, the trial court determined that the property that was, the personal belongings that was within the apartment had no value. What do we do with that finding?
Well, I think that you have to look at some of the case law that was set forth that indicates sentimental value has no value. But if a person has actual knowledge as to the value, which she did in those two sheets that were listed that she read into the record as to the value, the question becomes for the trial court, is that an appropriate value? Because if you have a penny of value in the property that's in the premises, then you got to move on to stage two, and you got to make a determination at that point, does liability get assessed to the landlord for an illegal self-help eviction?
What do we do with the trial court's determination that that the court did not believe your client at all?
Well, I think that you also then have to look at the trial court's conclusion that on page 5 of the trial court's decision, it clearly indicates that, quote, the court finds that competent, credible evidence supports a conclusion that Staley was no longer residing at the property when the locks were changed on October 29, and any remaining personal property left at the premises by Staley as of November 1 was abandoned. How can you change the locks, prevent somebody from entering on the 29th of October, and say that you abandoned it on the 1st? She still got a property interest in there when the locks were changed. So that's our position is that that was a self-help violation by the landlord. I think the court missed what they were trying to say, and you can't have 2 days of a possessory interest when you don't have a right to come in. And the appellee cites in their case, the one from Hancock County from 1977, I think the question there is, there was a temporary prevention of going back into the premises. What happened to Ms. Staley was a permanent prevention of going back into the premises. Doesn't matter if it's third party, doesn't matter if it's the direct party who's the tenant. They were preventing, Ms. Phillips prevented her from entering the premises when she changed the lock. One person's trash is another person's treasure. It doesn't matter what's in there. It's theirs. It's their property. And I think that leads us to, okay, if we find that there's an abandonment, can we come to the secondary cause? Is there attorney's fees applicable by statute under 532115C? And the question becomes at that point, as I alluded to previously, if you got a penny of damages to the tenant and there's a self-help violation, you have to go to the
That goes
assessment.
back to my question. The trial court determined that, in essence, there were 0 damages. So in order to get to attorney's fees, we have to deal with, first, what do we do with the trial court's determination that there were 0 damages?
I think you have to look at that and say the court was making its decision based on abandonment, not as to what was in there. Court said it was trash. Trash has value. I think if you find that there's an abandonment, it doesn't matter. You have to look to the second step under paragraph C of 5321.
But couldn't we find that the landlord did violate the statute, but because the trial court determined that the property had 0 value, that there were 0 damages?
Then I think that we might have a problem. Because I think you look at beyond 0. And I think that the trial court didn't want to look at that because they said, we determined that there's an abandonment and we don't have to get to that point.
Well, there was an alternative finding, wasn't there, by the court?
The court made 2 findings in its decision under A, subparagraph A, and under subparagraph C. And they found against Ms. Staley in both. So they said that there was appropriate notice to enter, and they said that that there was not a self-help violation. And I think if you look at the transcript and you look at the texts that were marked as exhibits on this, there was an ongoing dispute. Ms. Phillips was warned that if she didn't take her to court, there was going to be a problem, and the problem arose. The cleanest thing would have happened is if she would have filed a forcible entry and detainer. If she filed the forcible entry and detainer, we wouldn't be standing in front of this court no matter what the trial court's decision was at that point because there was a court order. The landlord would have had an opportunity to, pay their $50 non-refundable fee and have a physical set out, and we wouldn't even be making an argument. It didn't matter what was in there. It was a court-ordered set out at that point. Nothing we could do. So that's primarily the argument at this point. If you find that there's an abandonment, then our argument is that you have to step on to step 2, and you have to make a determination as to what, and have a hearing as to attorney's damages fees under
Thank you.
paragraph C. Thank you.
Thank you. Thank you for your argument.
Good morning, Your Honor.
Good morning.
Please, the court, I'm Paul Kraushaar for Applee. I think the key fact here is the trial court's finding that Ms. Staley's testimony was unworthy of belief. Basically, it held that it was disregarding everything she said. So much of what appellant is saying is irrelevant, where there's no manifest weight argument or sufficiency evidence argument. This is merely the application of law to fact. Here, there's testimony that Ms. Staley moved out by agreement. Ms. Phillips,
Where is that testimony?
I'm sorry?
Where is that testimony that she moved out by agreement? Because that gets to,
Yes, Your Honor.
that gets to where I began. In order for there to be an abandonment, there needs to be a termination of the tenancy or surrender, does there not?
Correct. Ms. Staley left by agreement, as discussed by Ms. Phillips in the transcript, page 51, Your Honor.
Okay.
She testified that they'd scheduled a date by which Ms. Staley would be out of the house. Ms. Staley took longer than that date.
Right, but the landlord testifies that she becomes upset because she had told the tenant to move. That, in essence, was the testimony at that moment, not because there was an agreement to move, but because she had told the tenant to move.
Well, Your Honor, she was going to give a 3-day notice, she testified, but then they had a conversation about the fact that it would be more harmful to Ms. Staley's record. I'm not sure that the landlord knew that Ms. Staley had this long history of being evicted, to the point where she could describe to the trial court what the process was and how it should have been done.
Well, the tenant had been a 6-year tenant, had she not?
I'm sorry?
Isn't the tenant a 6-year tenant at this?
Yes, ma'am.
Okay.
Yeah, but
And after the landlord gave the 30-day notice, then the tenant did not pay the following month of rent. That's the way I understood the facts. Is that correct?
yes, ma'am.
Okay.
Yes, ma'am. Then so they had this conversation. The tenant wasn't out by the date that they agreed, but when the landlord
That's what
comes
I'm getting
back.
to. Where in the record? Because that is very determinative of the outcome, whether there was an agreement or not.
I'm sorry, Your Honor, I can't hear.
Okay, I'll talk louder. Where in the record is the agreement of the termination of the tenancy?
It's from the testimony by the landlord at pages 49 to 52, where Staley rescheduled, specifically on page 52, Ms. Staley rescheduled her move-out for October 21st. On that date, the landlord finds her in the middle of packing. Ms. Phillips left. When they returned on October 22nd, she sees her move out. When she goes in on October 29th, everything, the dog is gone, there's no food, the personal toiletries and all that stuff is gone. It's just a pile of trash.
But the
So-
text messages back and forth, which that's not subject to somebody's interpretation. I mean, those say what they say, suggest that at the least she still had property there.
Well, Your Honor, the question is how does a reasonable person interpret that? She's moved out, she's got a caravan, she moves out all the property, she leaves. What she leaves behind is trash, and she leaves no apparent personal property of any value. I think a reasonable person, and in fact, the trial court has competent, credible evidence from which it concludes that the landlord reasonably made that decision. And that from that finding, appellant is not.
The trial. What's interesting is the trial court never says that the tenancy was terminated. If the trial court had said such, then perhaps we would be bound to that. What the trial court said is that she was no longer residing there, and residing is not determinative of the termination of tenancy.
Well, Your Honor, the residing is the key fact of the statute, because under A, it's for the purpose of recovering possession of the residential premises is the first requirement, and under C, it's the same. If the purpose of the landlord is not recovering possession because the tenant has abandoned, then there can be no violation of A or C. Would that make sense? I can't imagine how, if someone abandons something, that someone has done something in order to recover possession from the person who abandoned it.
Are you talking about abandonment of the apartment or abandonment of the property that was left in the apartment?
I think both, Your Honor. I think both of them have been abandoned. And in fact, Ms. Phillips had the property that actually appeared to be of some value set aside, and Ms. Staley actually picked it up. But it was lost in all the garbages when they were cleaning out the garbage in the house.
But wasn't the stuff set aside after the locks were changed? So the locks were changed, she set it aside when the locks were changed, correct?
Shortly after, I think the locks were changed on October 29th, Your Honor, and then on November 5th, when they came and there was a locksmith and Ms. Staley was retaking possession, I guess, of the property with a locksmith, then that's when she appears to have taken the property of value. It was set aside, it had not been cleared out. So if the property was abandoned, the premises were abandoned, then the landlord can't reasonably be found to have done an act in order to recover possession of the property because she had moved out by agreement. There was pretty clear testimony that they had come to an agreement, that Ms. Staley executed that agreement by moving out, and after the fact, came back in and attempted to resume possession and ultimately filed this lawsuit. Once you have the court's determination that that there was no cause of action and dismissing the claim with prejudice, then a lot of this case where law doesn't apply. This Thompson versus Allen case doesn't apply because in that case the trial court found that the tenant had not abandoned. Here the trial court finds that there is in fact no expectation of maintaining the property by anyone. Even if there was an expectation, that there was no testimony of value once the trial court found that the testimony was incredible. There has to be some testimony that the trial court hears the witnesses and decides there was some value in order to base a claim. And in fact, the trial court found that all of the testimony by the tenant was incredible.
But it was your client that testified that there was some Christmas stuff, a steamer, and a vacuum cleaner left?
Yes, ma'am.
Okay. Was there any testimony that stuff had zero value?
There was testimony as to value by the tenant, but none of those things were mentioned. The things that were mentioned were electronic gear and things like that, but none of that seemed to have been in working order. And so I think you can interpret that as being of zero value.
Counsel, if we were to determine that the landlord engaged in self-help and adopt the trial court's determination that whatever was in the property, in the apartment had no value, should there be an award of attorney's fees?
I don't think, Your Honor, I don't think so because, Your Honor, the point of the attorney fee provision is to prevent the landlord from excluding the tenant for purposes of regaining possession. Even if the court finds that she should have done the 3-day notice, she should have filed the actual eviction. First of all, I think that as a policy matter, that would be a pretty horrible decision because that means that every time that a person moves out of a premises, the landlord has to file an eviction action against them, even if there's notice and there's clearly an abandonment.
That argument is premised on that she did in fact move and yet left some of her possessions behind.
Well, I don't know that it's a practical matter. You can move and not leave anything behind. I don't know that, I mean, in the military, we
Well-
stand inspection, and you've moved everything out, and you get inspected by a white glove.
I hear what you're saying. This is, I mean, we've got these texts, so regardless of the credibility determination of the trial court, the texts speak for themselves, right?
Yes, ma'am.
And, you know, these texts from October 17th, where the landlord says, oh, we got to meet on the 21st, all your stuff has to be gone. Since you didn't communicate that you will be staying, there's going to be a per D fee after the 21st, right? And the tenant's response is, I will let you know if all of my things are out. So at that point, there's a clear communication that after the 21st, perhaps not everything will be out. And there's no concern, the tenant seems to accept that there is a fee afterwards that that she will be liable to pay after the 21st. Okay?
Yes, ma'am.
And
Okay.
this was a 30-day tenancy at this point. And then your client responds, I will stop the daily fee at the day that you are out.
Yes, ma'am.
Okay? So looking at, you know, let's forget about what was left behind, if anything was left behind, because someone can actually move all of their things and still have an expectation of tenancy, right?
Yes, ma'am.
Okay. So whether something was left behind or not is really not consequential. It's the communications that becomes consequential in this case.
Yes, ma'am, but the threat isn't, I'm going to change the locks and prevent you from accessing the property. The threat is, the implied threat, I think, is I'll file the actual eviction action. And if you don't want me to do that, you'll move out. So if that is the response of the tenant to the threat to file the eviction action, and you see, as the landlord did here, the tenant moving out, and you have I think it's a pretty clear agreement of the tenant to move out, both in the text messages and in their discussion that they had when the landlord shows up at the property with the painting contractor that she testified about. Then I think you can really only draw the conclusion that the tenant has, in order to avoid the eviction action, actually moved out. I don't think the presence or absence of
But isn't that inconsistent with the tenant accepting that they have a fee, that they have a continual obligation to make a payment?
Well, first, Your Honor, the tenant did not, in fact, make any payments. The tenant, in fact, had not made payments for some time. Whether the tenant protested that they should not have to pay a fee would not seem to be determinative when the tenant has not paid the past fees.
Okay, I understand your argument, and I thank you both. I thank you for your argument. I don't know if there's any other questions from the panel. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you both for your argument. We'll take the matter under submission and issue a timely decision. Thank you. Dennis v. Dennis. Good morning.
May it please the court. Morning, Your Honor.
Good morning. Would you like to reserve time?
3 minutes.
3 minutes.
Your Honor. Ready?
Whenever you're ready.
Your Honor, this is the appeal of Mr. Justin Dennis concerning the relocation of his child to the relocation of the designated school to the state of Indiana. In addition, it also involves another modification of the shared parenting agreement of these parties, which says that neither parent may remove and establish residence of the minor child outside of Hamilton County or the contiguous Ohio counties without the agreement of the other parent or an order from the court. So there are really two factors there, Your Honor. It's not just relocation of the school, it's also relocation of the mother at that time. And essentially what we're arguing, Your Honor, is, and we know it's a difficult hurdle in terms of the credibility of the witnesses in this matter, and we understand that the credibility rests with the trial court. But if you review the transcript in this matter and just the history of this case, you can see that the mother has intentionally deceived the court from the time of the initial decree of shared parenting in terms of where she resided at the time of the...
Is that relevant now?
It absolutely is relevant, Your Honor, because it wasn't disclosed at that time or exposed to the court at any time until the hearing on this motion when it was brought up to the court. The other reason that it's relevant is this, Your Honor. The address that's listed in that decree of shared parenting is the same address where Mr. Scott Owen lives. That decree of shared parenting went on approximately 5 years ago. The mother was intending to move in that address, stated that she has never lived there for one day, and Mr. Owen, even at this point in time, is not divorced, moved to Indiana with the mother of the child, falsified mortgage loan applications, etc., that have to be signed under oath, which bring his credibility into...
Aren't these matters that would have been before the trial court?
They
the trial court to consider and
They
determine
were
credibility?
before the trial court, Your Honor, and it was a matter of the issue of addressing the credibility of the witnesses in this matter. And I really think the person who got it right was the GAL, who has probably 30 years' experience doing these type of cases from being a magistrate in juvenile court. But if you look at what the GAL said, this is not just an issue of the mother and Mr. Owen in terms of their credibility with the court, but if you look at what the GAL said, it's a spillover onto the minor child in terms of how the mother communicated with the minor child, and how the mother advised the minor child not to communicate concerning relocation to the state of Indiana or the fact that she was moving to a new school, which impeded the GAL's ability to really assess or get the information from the minor child. And if you look at page 9 of the brief that I filed in this matter, Your Honor, and specifically the GAL's testimony concerning this matter, I think it's quite clear that the entire situation with this case boils down to one real simple issue, which is when the mother came in and testified, when she brought Mr. Owen in and testified, and even when they brought the minor child in, their testimony was essentially manufactured. And I believe that the trial court was so enthralled with this forever home that the mother was going to obtain or reside in that swayed the court's determination in terms of being able to move the child. In the trial court...
I'm struggling to understand. So the trial court's job in this case is to determine whether moving to Indiana to go to this school district was in the child's best interest. So why does it matter whether, the mom lied about something that happened 5 years ago? I mean, it's about the school district, and it's not like she, was moving 6 states away. I'm struggling to understand your argument here.
Well, Judge, if you look at this case, when you lie to a court, whether it's 5 years ago, 2 years ago, or 10 years ago, I really think that that's a big issue for a court. And not only did she lie at that time and deceive the court, she relocated 2 additional times and deceived the court on those because she never filed a motion or intent to relocate, which is required by Hamilton County's rules. So essentially, she's testifying before the court in an untruthful manner, which affects her credibility, and she has a demonstrated track record of not being truthful with the court. She filed her notice of intent to relocate after she had in fact closed on this home and had moved at that point in time. Are those issues big issues? Well, evidently the state legislature believes it is, because there's a requirement for a notice of intent to relocate. There's a requirement in the local rules of a notice of intent to relocate. And that notice of intent to relocate is required to be filed in advance of the move. I could foresee circumstances where that might not be possible on a job relocation. This is not a job relocation issue.
So what is the legal effect of the mother not following those procedural requirements?
Well, the legal effect of her not filing those requirements is essentially at that point in time, if those requirements are not enforced, everybody at 800 Broadway that's involved in a divorce action, the notice of intent to relocate is mere fluff in every shared parenting plan.
Well, but that's a potential practical effect. What would be the legal effect?
Well, the legal effect is she should not be permitted to move until she obtains an order of the court. She moved in advance of that order to the state of Indiana. Her shared parenting plan states that she will not move from the state of Ohio or any of the contiguous counties. It says it right there in the shared parenting plan. That's what these parties agreed upon.
Was there a contempt filed by your client?
No, there was not a contempt filed by my client because he filed a motion to oppose the relocation of the minor child to the state of Indiana. That's what he did. But we believe that the real issue is, and if you look at the case that I cited from the JC case, I think that court really kind of says it, which is your rules don't matter, the statute doesn't matter. I'll relocate if I want to relocate, and I'll go where I want to go whenever I want to go there. That's essentially what occurred in this case. And in order to establish the right to move or the right to relocate, I mean, this to me is when the mother instructs a child, told the child not to talk about the location of the new home to the GAL, would not let the child talk about the forever home until the mother actually moved into the home. And this is all in the transcript. The mother actually testified that we don't lie and we don't encourage lying, and the child gets punished for lying, but what they exhibit to the child is the same thing. Now, if you're fine with letting them move, letting them relocate because you think the school's better over in Indiana, it's 25 minutes of additional time, which may not be that big of an issue, but if you do domestic relations law, 25 minutes of time away from the father, time to pick up the child, relocation of activities, et cetera, are big issues. Even the trial court says, well, these parties don't live in the Harrison School District anymore. Well, the mother was in charge of enrolling this child in school. It didn't make a difference where the mother lived. She enrolled her in the Harrison School District, even though she didn't live in the Harrison School District for 3 of the moves. So if you want to condone that type of
Well, Mr. Kelly, your client was aware of that, so when
Please.
you're arguing he was complicit, your client knew where she lived outside of Harrison, so.
They were initially in the Harrison School District at one time, and what is not in this record is whether there was open enrollment or not open enrollment at the Harrison School District. That's not in the record because, believe me, I looked for it. That's not in the record, but if there was open enrollment in the Harrison School District, the child could still be in the Harrison School District. But the bottom line is, it'd be difficult to get the child in the Harrison School District if the child's in the state of Indiana. I don't know you could have open enrollment and have a child from Indiana attend a school in Ohio. But the bottom line of the situation is, if you look at this situation and what transpired in the trial court in terms of the testimony by these parties, I think it's categorically palpable that she did violate the statute in terms of relocation. She did violate the statute in terms of it violated the local rule. And finally, I would
Kelly,
say,
I want to make sure that I understand your argument. Is this what your argument is, that due to mother's litany of violations, that it was an abuse of discretion for the court to make the determinations that it made with regard to the best interest?
absolutely, Your Honor. I don't believe how the court could even find the woman credible, because she started telling untruthful statements to the court starting in 2016, and she didn't stop up through this hearing. The individual who came in to testify on her behalf, Scott Owen, he was untruthful in terms of how long he stayed over in Indiana. The GAL got it right. The little child wants these two parties to get married. The mother's divorced. The boyfriend's, he's not divorced at the present time, Your Honor. And the bottom line of the situation is, when's enough enough? I mean, how much can the court take in terms of representations to the court and intentionally trying to deceive the GAL, who's appointed by the judge, not to have the child testify truthfully or to curb.
How old was the child at this time?
Please?
How old was the child at the time of the hearing?
I believe the child was 9 years of age, Your Honor.
Okay, and it's my understanding that the trial court did conduct an in-camera interview?
They did.
Okay,
They
thank you.
did. And we're not privy to that, Your Honor.
Yes.
And I wasn't there at the time that this trial took place, so I don't know how much time that the trial court spent with her. But I think that if you review the decision, what the judge talks about, for the most part, is her moving to her forever home. And I just think that when you really look at this case, in terms of the movement of this child and what was presented, yeah, it's built on quicksand. But that may be for another day, Your Honor, or maybe for another motion. But I think that the real issue is that you have litigants participating in a court hearing. I think that the least you could expect from being on the bench is that their testimony would be truthful and would be accurate and recognize the solemnity of the proceeding that they're involved in and that people's rights are at stake in that
Understood,
proceeding.
Attorney Kelly. I'm
Thank you.
going to reserve your time.
Bill Weisel for Ms. Dennis. May it please the court. With regard to father's two assignments of heir, he alleges abuse of discretion. And Mr. Kelly's arguing that basically the credibility of his witnesses is abuse of discretion. But when you look at the actual legal definition, it's not just making the wrong decision. You have to find that it's unreasonable, arbitrary, or unconscionable. And in nowhere in the brief does the appellant argue that any of the decision by the trial court was one of those three things. They argue that father believes that mother lied, that Scott Owen may have lied, and I don't want to go down those red herrings because that's irrelevant to the best interest standard. When you look at the best interest standard that was applied by Judge Searcy, she did consider the original intent of the shared parenting, naming mother designated for school purposes. She considered the distance of the move, and I know appellant argues it was out of state, but this was from Harrison to Guilford, Indiana, which is a shorter distance from Harrison to Milford. So mother certainly took that in consideration, and there was evidence as to the distance was appropriate, and she didn't move all the way across Hamilton County an hour away. There's evidence in the decision that Judge Searcy considered mother's work schedule, father's work schedule, and that he was self-employed and he had a flexible work schedule. There's evidence in the decision that Judge Searcy considered Riley's extracurricular activities, that she considered Riley's wishes during the in-camera interview. And she even acknowledged she considered the GAL's recommendation and said that the stability issue that was raised by the GAL doesn't rise to the level of concern for the court. And finally, she compared the schools, Guilford to Three Rivers, and made a comparison. So to say that this was all hinged on two witnesses that were lying to the court, I mean, one, it's not fraud on the mortgage company, it's not clear title in Indiana. So they're going to have problem transferring the title, but that's not fraud. That's just clear title. With regard to Scott Owen, he's only mentioned in the whole decision on one small paragraph on page 3 of the decision, in the factual section. Never once is Mr. Owen mentioned in her decision that impacted her decision. You could take out the testimony that Judge Searcy wrote in her decision of Scott Owen, and it would not impact this case. Because a lot of the issues that the appellant's bringing up just aren't relevant to the best interest standard. And again, he's got to show that it's unconscionable, arbitrary.
They are relevant to the stability.
I'm sorry?
They are relevant to the issue of stability.
So I do want to address that because I think we skipped over pretty fast on that. What happened is mother filed the intent to relocate to go to Indiana while she was living in Harrison. Her lease goes up in Harrison. She moves to Delhi because she can't leave the state of Ohio for visitation purposes. So rather than taking the kid to Indiana and be in violation of the court order, she stays in Delhi with, I think, her grandpa's parents, she testified, that lives in Florida, and stays in Delhi, which is in Ohio, in Hamilton County, until Judge Searcy rules on her motion to relocate. So had she done anything wrong, father was represented by counsel, they would have filed contempt. They could have filed contempt on any of those times, and he never did. So,
as I understand the argument from the appellant, is that there was a history of misrepresentations, and that in the determination of stability, that this is the forever home. There's a discussion of the forever home, so I'm characterizing that as stability. Okay. That there was an abuse of discretion in that determination, given the history.
But again, I don't think that's abuse of discretion saying she didn't update her address with the court, and now you have to reverse the whole decision. I don't think that's abuse of discretion. I think that goes to credibility. She heard the evidence. That, as far as how much weight the trial court put on that factor, she obviously didn't put that much weight because she considered the GAL's recommendation and said that her concern is not the stability with the forever home. But father, as Judge Winkler said, was complicitous in the whole thing. He could have alerted Harrison Schools that she's living in Delhi, never did, because he wanted their daughter in Harrison until they figure out the next move. He knew where he was living the whole time, and never once was there a motion for contempt. So that was a non-issue. It's only when they want to pick the new school he brings up this issue of stability and makes a big deal about it. But he never made a big deal about it before, and he had every remedy in the world to do that. So again, I think that's a red herring. I know it's relevant to the stability aspect, but in the grand scheme of things, there's overwhelming evidence of the best interest standard that was applied properly. It's not abuse of discretion. The trial court followed the law. And I think to say that these lies and deception can carry the day just isn't enough when you actually look at the law and what abuse of discretion is. So for those reasons, I'm asking you to affirm the trial court. If you have any questions, I'm happy to answer them.
Thank you.
Just briefly, if you look at the parties' decree of shared parenting, it says both parents shall both be designated as the residential parent of the minor child for school registration and other purposes. That's at the top of page 3. Then, if you look at page 6, it says neither parent may remove and establish residence for the minor child outside of Hamilton County or contiguous Ohio counties without the agreement of the other parent or order from the court. That's what their document says. Now, as far as the credibility of these parties and what could be presented, I would only bring to your attention the fact that these two individuals are police officers. Mr. Owen's a police officer.
Is that part of our record?
Yes, it's in the record. They're police officers. They're aware of what the criminal law says. And just if you go through, I would just address you to 292111, 292131. Both of those have to do with obstructing justice, Your Honor. And if you take a look at those and take a look at this case, it is almost hard to believe that you can bring somebody into a courtroom who is a police officer, have them testify the way they do, and essentially conceal evidence, and have a court get so enthralled with the forever home that you let the child move from the state of Indiana. Because the bottom line of this case is, Your Honor, both of these parties, and it's replete in this record, and it's actually emphasized by the GAL, both of these individuals were untruthful. So if you're talking about credibility, and if you're talking about believability of witnesses, et cetera, you could not look at this record and provide any credibility to Ms. Dennis in this matter. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue you a timely decision. Have a wonderful afternoon.
You do the same.
Thank you. The last case we have is case C210355, State of Ohio versus Ricky Brown. Thank you for your patience this morning.
I'd like to reserve 2 minutes for time.
2 minutes?
2
Okay.
minutes, please.
Whenever you're ready.
Your Honors, the trial court here erred when it did not grant the new trial motion of Mr. Brown, which was based on surprise at trial that could not have been guarded against with due prudence. And I want the court to understand that the surprise rose out of Holly Smothers' testimony that the let-go account of this Danny Buckley, this person that she allegedly corresponded with to sell her car, could be tied through an email to the Facebook page of Ricky Tan, which was in fact Ricky Brown's Facebook page. That was the linchpin testimony here in this case, which supported the eyewitness testimony of Smothers and Bryant, which had some difficulties because they didn't say anything about tattoos, they didn't say any tattoos. But it gave the court a reason to convict Mr. Brown other than just the identification testimony. And it was unfair because that was not...
Who is the party that failed to disclose?
The state didn't disclose that.
I know, but
the police didn't. The police didn't
Let me
know.
be more specific. Was it the investigating officers, or was it the prosecutor?
It was the witness who didn't tell the officer.
So it was the witness.
It was the witness, Ms.
Okay.
Smothers. And I think there's a lot of shady stuff here. I lifted it in page 10 of my brief here.
Mr. Trabb, I'm sorry to interrupt you, but let me ask you this. I know you practiced before me many times, and in the state's disclosure of the evidence under 4C, it says Charlene Johnson and Holly Smothers positively identified the defendant through a photo lineup as an individual who pulled the gun on them with 100% certainty. And I'm getting to the question part. I mean, if you had seen that in the state's response to the demand for discovery, I'm assuming you would have filed a motion to suppress that identification as being unduly suggestive. At least you probably would have explored it. Is that fair to say?
Judge, I practice. I would have filed a motion to suppress, even though there's no grounds for it here because there's no impermissive suggestibility on the part of the state here. But I would have filed a motion to suppress, and maybe this would have come out.
Well,
as
yes, that's the point.
Yes.
Okay.
That wasn't done here. I think defense counsel, maybe she filed a law and didn't have a really good reason to file one. I always file sort of defensively because I like to talk to witnesses, but.
Well, you get to hear from the witnesses prior to trial.
Yes.
And ordinarily you don't, right?
And ordinarily you don't. That's right. So it's really key here to understand, and I don't know if I did a good job on my brief, and that's really why I'm here today, is to make sure this court understands that this is the linchpin testimony. Like I can trace Danny Buckley to Ricky Tan to Ricky Brown, and this must be the guy that robbed me. And this was elicited, came out from the first time at trial, and the defense counsel was clearly surprised by it and confounded by it. And she asked some questions. She did what she could, but it wasn't enough. And of course, the trial court then has grounds to convict Ricky Brown because this testimony is uncontradicted, unchallenged.
And isn't part of your argument that with the technology, that the technology doesn't work the way the witness testified that the technology worked? Am I understanding that right, that was, it seemed as if that was being pursued at trial?
The argument is a surprise at trial because this wasn't known to defense counsel.
Oh, I understand.
She didn't
it's a
have the
surprise,
opportunity.
But isn't that part of the argument, or is that not part of the
I
argument?
don't think she was able to contest the technology because of the surprise.
Okay.
If she'd had knowledge of this before the trial, certainly she would have been able to do her own investigation, to hire an expert, to see if this is true, if you really can take an email and get it to a Facebook. I don't know. I didn't do my own investigation. I don't know if it's true. There's a lot in this record to suggest that Holly Smothers was lying about that because she never told the police officer how she did it. She lost her phone. The Detective Kaiser says he's never had a case setting up a robbery where there's no, with text messages where you can't find the text messages that sent up the robbery. She wouldn't bring her phone records down to Detective Kaiser to find them out. He never subpoenaed any records from Let Go. There's a lot. Speculating.
And there was wasn't there a disparity of the description?
Yes, there was disparity. And the biggest disparity was that Mr. Brown has tattoos up and down his arms, and the robber had neither. And none of the two witnesses mentioned any tattoos at all.
Let me ask you another question, Mr. Trapp. By the way, I thought you did a great job on your brief.
Thank you.
Is there any evidence in the record that defense counsel contacted any of these 11 witnesses listed by the state of Ohio in their response to her demand for discovery? In other words, I'm focusing on Charlene Johnson and Holly Smothers. She knew who those people were. Is there any indication that she contacted them to find out what their testimony would be prior to trial?
I don't think there's anything in the record, Judge. It's been a while since I reviewed the whole transcript, but I don't think there's anything in the record.
On page, I'm looking at the transcript, and it looks like on page 161, 162, it talks, Detective, let me just make sure I am, no, wait a minute, that was defense counsel arguing that. Never mind.
So if I may, there's surprise here that couldn't have been guarded against. I know defense counsel filed a motion for new trial. She found it on Brady. It's not really a Brady violation. It's surprise. She put surprise in the motion. I know there were no affidavits supporting it, but the state didn't point that out. The state didn't respond with any affidavits of their own. And the trial court went ahead and decided this motion. It decided the motion on improper grounds. It decided the motions on newly discovered evidence, which was not the issue, the true issue here. I just mention this because I don't want the court to think that this new trial motion has been defaulted in any way. The court went ahead and ruled on it. I would ask the court to consider it as properly filed. This case just resulted in a lot of unfairness to Ricky Brown, so much so that this trial was not a good vehicle in order to determine his guilt or innocence. And if you have any questions, I'd be happy to answer.
I do another. Sorry, Mr. Trapp, but the trial court was aware that I believe it was Smothers or Johnson found your client's photograph on Facebook, provided to the police. The police did a 6-pack or 8-pack, whatever it was, and she identified your client. But the court was aware of the way in which this witness was able to determine as best she could that your client was the person that robbed her. So my question is, the judge knew that, right, during the trial?
Yeah, it came out in trial.
Right.
To the extent that it was brought up and cross-examined, it came out at trial that she somehow connected.
But my point is the judge could have taken that into her calculus when determining the credibility of your witness, whether it was a good idea or bad idea. Everybody knew the question was identification.
I think she's assumed to have taken it in.
Mm-hmm.
Okay. That goes to my last assignment of error, that she just misplaced the credibility of the witness. But in this case, is wound up like that. All these assignments interrelate almost. But yeah, it came out at trial. Defense counsel did the best she could to try and challenge it. And she was handicapped. She didn't have any way to say, no, you can't do that. No, this technology doesn't work that way. Who knows? She didn't do that. So considering how important it is, because eyewitness testimony is notoriously unreliable, And they had problems. They didn't see the tattoos. One of the witnesses said there was another black man with them. One didn't. There's some unreliability here. This is the linchpin testimony that let the court convict Mr. Brown, and it's just unfair to him for his counsel to be surprised by this testimony at trial. And I just want to pass on to my second assignment of error, and they all kind of flow together. But Mr. Brown was tied in handcuffs.
I think it would be good for you to address your fourth assignment of error, and that's the conviction of robbery of Smothers.
Okay. Smothers handed her money, the $600 to Bryant, and then the robber robbed Bryant. Smothers wasn't robbed. Maybe it's a theft of Smothers' money, but it's not a robbery of Smothers. So there's insufficient evidence as to count 5.
Wasn't she just handing the property to the other person to hold it while she got out of the car?
Yes.
Okay.
Yeah, but the gun wasn't pointed at her. The gun was pointed at Bryant.
She was on the sidewalk at the time, was she not? She was some distance. It sounds like she was some
I think she was
distance in
some
the vehicle.
distance away, right. My second assignment error goes to the fact that Mr. Brown was tried in handcuffs. And I know it's a bench trial, but I provided in my reply brief some legal authority, it's an Illinois case, that this is not harmless error to try a person, even at a bench trial, in handcuffs. Because, and here Ricky Brown had to assert his innocence, had to assert his alibi, had to do all that while he was handcuffed. And the only way we know about this is because he had to be unhandcuffed so he could show the judge his tattoos, which were up and down his arm. It's unfair to him. It's a denial of due process. I know it's a bench trial, but the crucial thing to remember here is this is a vital point of his testimony, and the trial court is listening to him declare his evidence while he's shackled.
But now, Mr. Trapp, had this been a jury trial, if one of the jurors may have seen your client shackled, the judge would give a curative instruction that nothing is to be taken from that, only that he could not make his bond. So the judge knows that in a bench trial.
I know, but that's why in a bench trial, she certainly knows it, but how can it not affect her that he's there shackled? Well, there's an Illinois case.
She instructs the jury that it shouldn't.
Yeah, so I think that's an error here, not harmless. And then the third assignment error goes to ineffective assistance of counsel. Trial counsel here didn't stop the proceedings and ask for a continuance when she was surprised at trial so she could do her investigation, get an expert, stop it. She didn't do that. She let her client be tried in handcuffs. That was ineffective assistance. And then my last assignment of error, Your Honors, is manifest way to the evidence here. The trial court put too much weight on Holly Smothers' testimony and Brian's testimony and didn't evaluate it, didn't consider that they missed the tattoos on the arms, didn't consider that the photo lineup was meaningless because it was tainted, because Smothers had seen a picture of Mr. Brown. She had shown that picture to Bryant, and of course, oh yeah, that's the guy that robbed me. The photo lineup didn't mean much. She should have given weight here, less weight to that than she did. So I'd ask you to reverse this matter and send it back to the trial court for a new trial. Thank you.
Thank you.
Okay.
Good morning, Your Honors.
Good morning.
Police Court. I'd like to begin, if I could, with the second assignment of error, just because I noticed that I misstated my issue presented for review. I don't know if the court had caught that I excluded the word "not." The defendant did not suffer prejudice by being handcuffed during a non-jury trial, and I think that the record bears that out. When we talk about the law that applies to non-jury trials, in that instance, there's some sort of indication, the record supports that there was a communication issue between counsel and the defendant because of the issue of being handcuffed, and that is absolutely not borne out in the record here. There was no indication ever that defense counsel was having any issues communicating with her client due to the handcuffs. It only came out, again, because he needed to remove his jacket to demonstrate, and this was during his direct testimony when he was presenting his defense, that he wanted to display the tattoos to the trial court. So I certainly don't think that that amounts to a violation with regard to that second assignment of error. With regard to the first assignment of error on Criminal Rule 33, I think there's no indication that Judge Cross here misconstrued or had any misunderstanding of the essence of the motion. And I think that her written decision here bears that out. She very clearly understood the argument that was being made with regard to the connection. And here, all of the information was there. Certainly they knew, defense was well aware that the Facebook photographs were something that the state wanted to present. There was also the witness list. And in fact, there was actually there wasn't a motion to suppress, but there was a pretrial motion in limine with regard to those Facebook photographs.
But there is nothing beforehand suggesting that the defendant or his counsel knew that the only reason that and I found this testimony, that the only reason that the officer was able to connect the person from the LECO app to Mr. Brown was because of Ms. Smothers connecting it through Facebook.
Right, and that connecting the dot, I mean, the evidence that's being presented, there's no element of surprise here that the state doesn't have to provide, I mean, all the pieces are there. The state doesn't have to connect the dots on each, and I don't know, in fact, whether the state was aware of that actual connection until these matters got presented during the trial either. And I don't think that constitutes an element of surprise. The witnesses could have been contacted, certainly. I mean, all of the evidence was there. The witnesses, this wasn't a new witness or anything. Those witnesses could have been interviewed, and all of that could have been borne out through that.
Wasn't there, and I'm trying to remember if it was through discovery or through testimony, or that the connection to the defendant was made through the internal usage of a special unit of the of the police department?
Well, I think that...
So that's what had been communicated.
And I think that's... Judge Cross addressed that in her ruling, that when... And I... Certainly technology is not my forte either. But I think that once the email that's being used in the app is identified, then making that connection to the owner of that email. And that's where that information came to bear to the investigator who presented it then to the other unit, if you will, of the police department that would make that. Because you get more specific information, obviously, once you have an email, but to get the more specific information about the owner of that particular email address, that's where that came in. And I think that Judge Cross, her ruling on that motion, she clearly understood. This wasn't a misunderstanding or her misconstruing the motion. I think Judge Cross was very clear in that in her ruling. With regard to I think it's the third assignment of error with regard to the aggravated robbery. I think it's important for the court to bear in mind that aggravated robbery does not require an element of force against a specific victim. This is the span of a car. That's the distance. We have Ms. Smothers exited the car because she's going to leave with the defendant to go see the car that she's supposedly purchasing, and the other victim is in the driver's seat. This is a very close proximity that she is with the weapon. In fact, either of those women could have very easily have been shot. So I don't think that there's a sufficiency issue with regard to the identity of which victim is associated with
But the ag
the different
robbery was
counts.
dismissed, was it not?
One.
Yeah.
One
with
of them.
regard to Smothers.
Right.
I mean, sorry.
Yeah,
with regard to Smothers, the ag robbery was dismissed. So how do we have the robbery when the ag robbery was dismissed?
I don't think it was dismissed. I think it was the trial court's
he
finding.
quit it. Yeah.
Right. She found Judge Cross found the defendant guilty on aggravated robbery as to the person who owned the money, who stepped out beside, but found him guilty of robbery on that victim. So he was found guilty on each victim, but his argument is that that the Judge Cross erred in finding him guilty with regard to the aggravated robbery of the person that he didn't point the gun directly at. I think that's the essence of his argument, and I don't think that that's required as an element, that the force element be toward a specific victim. And again, if you just look at the circumstances here, this is not, one person is standing down the street and the other person is in the car. This is a very close proximity within that span of that car, and I believe she said she had like it wasn't a large car, it wasn't an SUV, it wasn't, it was just a standard sized car, and I don't think that is a significant error in this case. Again, I think Judge Cross clearly set forth, and this whole case is about credibility, and I think Judge Cross, in rendering her decision, she explained herself very clearly that she did believe the two witnesses who were the victims in this case, and did not at all believe the defendant and his alibi witnesses. Unless the court has any further questions, I will submit them. Thank you.
Your Honors, Smothers didn't tell the detective how she got to the Ricky Tan Facebook page. She didn't give an email, so they didn't know. And then she just gave the Facebook pages to Detective Kaiser of Ricky Tan. And
That's not what it says. It said Ms. Smothers actually found that Facebook page as a result of her own investigation. Did she not? Yes. And all the pictures she emailed to you, that was something she found on her own. Yes. So you personally did not subpoena any records, and then it goes on. So it sounds like, from this testimony, it sounds like she did send those pictures to him.
She sent the pictures. She didn't say how she could connect, how she did her own investigation, or the email that she found to connect that she used. She's found some email on Let Go Act that she used to connect to the Facebook page. She just sent the pictures, and then I think they used their facial recognition to identify Ricky Brown. I just want the courts to just reemphasize, this is crucial testimony that bolsters the eyewitness testimony, and it makes it unfair to surprise counsel at trial with this crucial linking testimony. And then, because credibility was the issue. She said, this is a credibility determination, but this surprise evidence bolstered their eyewitness testimony. I don't have anything else. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a wonderful week.
Court of Appeals for Appellate